asking you about. This wasn't the case. I'm asking you what you believe. And I don't appreciate you dodging my question. Now, this is a serious position you've been nominated for. Do you believe that someone who is against white supremacy also has to be against voter ID laws?
Senator, no. The Supreme Court has held that photo ID.
What do you believe?
I believe that the Supreme Court has held that.
What do you believe personally?
I believe that photo ID laws have been held to be constitutional.
Do you think voter ID laws are appropriate or inappropriate?
I believe those are questions that election officials.
Do you believe that voter ID laws are appropriate or inappropriate?
I believe that photo ID laws have been held to be constitutional. I believe there are cases in which they are.
What do you believe?
I believe there are cases in which they are appropriate.
What do you believe?
I also believe there are cases in which they can.
What do you believe?
Senator, let her answer, please.
I'm trying to. We both know what's going on, Mr. Chairman.
Let her complete the sentence.
Well, let me do my own questioning, Mr. Chairman. I appreciate your help, Professor. Do you believe that voter IDs laws are appropriate or not?
I believe there are circumstances where photo ID laws can be constitutionally implemented. And I believe that the Supreme Court has also held that there are circumstances when they would not be constitutionally permitted.
What happens when a Senate nominee is asked to defend statements they made years before appearing before the Senate? That was the central tension in this exchange involving Senator John Kennedy and two judicial nominees whose previous comments became the focus of questioning. First, Kennedy questioned Professor Merrill about a 2017 statement in which she had argued that opposing white supremacy while refusing to repudiate voter ID laws was inconsistent. Kennedy wanted to know whether that was still her personal view. But Merrill repeatedly separated her past comments from her role as an advocate. And that's where Kennedy became frustrated. He wasn't asking what she had argued in court. He wasn't asking what position her clients had taken. He wanted to know what she personally believed about voter ID. Eventually, Merrill acknowledged that photo ID requirements can be constitutional under certain circumstances, while also noting that the Supreme Court has recognized situations in which voting restrictions could become unconstitutional. That answer is important because it reveals the complicated reality behind the political shouting match. Voter ID isn't simply a question of constitutional versus unconstitutional. The Supreme Court has upheld certain voter ID requirements while also leaving room for challenges involving how those laws are designed and applied. But Kennedy wasn't finished. He turned to another nominee, whose previous statement at Princeton had reportedly claimed that police killing unarmed black men happened every single day in America. Kennedy immediately challenged the statement. Do you believe that? Instead of defending the literal wording, the nominee explained that the statement had been made in an advocacy context and was intended rhetorically. And this is where the hearing became much more interesting. Because there are really two different questions being asked. The first is whether an advocate should be allowed to use provocative language when arguing for a cause. The second is whether someone who used that language can later convince senators that they will approach cases impartially as a federal judge. Those are not necessarily the same question. Advocates often use strong language. That's part of political and legal advocacy. But a federal judge occupies a completely different position. Judges aren't supposed to represent one side. They're supposed to apply the law, even when the outcome conflicts with their personal preferences. So Kennedy's concern about judicial impartiality is legitimate.
Okay. All right. Ms. Chaudhry. Saying your name right?
It is Chaudhry.
Chaudhry. Thank you for correcting me.
Thank you.
In 2015, you were on a panel at Princeton University. You said that the killing of unarmed black men by police happens every day in America. Did you say that?
Senator, I don't recall the statement, but it is something I may have said in that context.
You think it happens every single day?
Senator, I believe in that statement, I was making a comment in my role as an advocate, and I was engaging in rhetorical advocacy, which
But do you believe that police officers kill unarmed black men every day in America?
Senator, I believe the killing of unarmed citizens by law enforcement is tragic, and I believe in that instance.
I think it's tragic too, but do you believe, this is a really simple question, Counselor, do you believe that cops kill unarmed black men in America every single day? You said it at Princeton.
Senator, I said it in my role as an advocate.
Oh, okay, you didn't mean it.
Senator, I said it in my role as an advocate to make a rhetorical point.
So when you say something that's incorrect, it's okay to excuse it by saying, oh, I was being an advocate? What do you believe? Do you personally believe that cops kill unarmed black men every single day in America?
Senator, I believe law enforcement have an important and challenging job in this country.
That's not what you said, though, Councilman.
Senator, I say before you here today that I do believe law enforcement have a difficult and challenging job, and I also understand the difference
I just think that's an extraordinary statement to make with no data to back up. None whatsoever. There's no basis for you saying that. And you knew it then and you know it now. How can one possibly believe that you're going to be unbiased on the federal bench?
Senator, I believe my record shows that I have worked collaboratively with law enforcement in Boston, Chicago, Mississippi, and Milwaukee to solve complex problems to promote constitutional, effective, and safe
Your record
policing.
shows that you believe cops are guilty until proven innocent. Your record shows that if a cop shoots a criminal, it's the cop's fault. And if a criminal shoots a cop, it's the gun's fault. I've read your record. Ms. Murrow, and I don't appreciate you not answering the question.
At the same time, there's another side to this exchange that shouldn't be ignored. A lawyer expressing a strong opinion as an advocate does not automatically mean that lawyer would be an unfair judge. Lawyers are expected to argue aggressively for their clients. The real question is whether they can separate advocacy from judging. And this is where the hearing becomes bigger than John Kennedy versus two nominees. It's really about whether Americans should judge judicial nominees primarily by their old political rhetoric, or by their demonstrated ability to follow precedent, interpret the Constitution and apply the law fairly. Kennedy clearly believed the nominees' previous statements deserved scrutiny. And frankly, senators have every right to ask those questions. If someone is being considered for a lifetime position on the federal bench, the Senate should examine their public record. Their writings matter. Their speeches matter. Their legal work matters. And their previous statements can absolutely tell senators something about their judicial philosophy. But there is also a line between legitimate scrutiny and turning every controversial statement from someone's past into proof that they are incapable of being impartial. That's where the debate gets complicated. Kennedy's strongest argument was not that these nominees were automatically biased because they had once made controversial statements. His strongest argument was that nominees should be willing to explain those statements honestly. If a statement was rhetorical, say so. If the position has changed, explain why. If the statement remains your belief, defend it. What creates suspicion is not necessarily having a controversial opinion. It's appearing unwilling to clearly explain what you believe when you're being considered for one of the most powerful legal positions in the country. Confirmation hearings are not